We do have an email from a viewer. Kelly asks, my brother was seriously hurt at work because of safety issues which were ignored by the company. He will get workers' comp, but does that mean he has no other legal recourse against his employer?
Yeah, I would have to know a little bit more about it, but yes, typically that's going to be his only recourse. That's what we call the exclusive remedy, which is a fancy phrase for it's your only thing you can do. And when it comes to workers' comp, if you cannot sue your employer for negligence. So if they did something that was wrong, typically you're still going to be you're still going to be limited only to workers' comp. Now, like I was saying earlier, if it was another company that was involved, say a subcontractor or something like that, and they did something to cause your injury, then you would have workers' comp and what we call a third-party claim. But I was talking to our guest, which I'll introduce her in a second, because she's an expert on all this, and I asked her earlier, I said, is there anything else they can do? And she said, the only thing that you can get outside of workers' comp against your employer or a co-employee. So let's say that one of your workers or supervisor removed the safety guard from a saw or removed the safety guard from some other apparatus and you were injured, then you could have something other than just workers' comp. But again, it can all be confusing. So if you're ever injured on the job, first thing you need to do is talk to someone, find out what your rights are.